In 2009, 7 Subpostmasters told Computer Weekly that Horizon could report apparent cash or stock shortfalls operators then had to cover. Months later, affected operators formed the Justice for Subpostmasters Alliance. Why did 555 take Post Office Ltd to court? The Court of Appeal described Horizon as the system that calculated the cash and stock a branch should hold. When its figure showed an apparent gap, the operator could settle in branch by paying money into the branch, or settle centrally by having the amount taken from future income. Horizon offered no way to challenge that figure before the next trading period began. An operator could call the post office helpline, but could not change the balance inside the system. Computer Weekly reports that, in 2005, Post Office auditors told sub-postmaster Jo Hamilton that she owed £36,000. Her case then moved from a disputed branch account into criminal procedure. Post Office Ltd prosecuted her for theft and 14 counts of false accounting. The documented progression from an asserted debt to criminal charges shows that a branch accounting dispute could carry consequences far beyond the counter. Hamilton's case gives the wider Horizon story a human scale before the later group campaign. It also shows the post office in more than one role, overseeing the branch relationship and bringing the prosecution. The report records the demand and charges, but it does not establish why the apparent shortfall arose or show that every Horizon case took the same course. Computer Weekly reports that the post office offered Jo Hamilton a plea arrangement. Under the deal, she could plead guilty to false accounting and have the theft charge dropped. Hamilton accepted. The arrangement created a narrow choice: avoid the theft charge, but accept a criminal conviction over accounts tied to the disputed shortfall. At the time, the post office treated Horizon figures as evidence of an actual loss and generally expected the sub-postmaster to prove the figures wrong. Hamilton was therefore not cleared. She was left with a false accounting conviction and, according to the report, probation. The financial consequences reached into the rest of her life. She remortgaged her house, and villagers raised £9,000 to help her meet the burden. The documented impact was personal: a conviction, a home used to raise money, and a community trying to help. Before Jo Hamilton's 2005 case, Alan Bates contacted Computer Weekly in 2004 about unexplained shortfalls. He refused to sign accounts showing apparent Horizon losses because he believed computer errors had caused them. Computer Weekly reports that Post Office Ltd then terminated his contract, ending his branch business and planned retirement. Bates's former branch was in Craigiedown, Llandudno, where a banner publicized a website he created to find other sub-postmasters reporting Horizon problems. The public search connected reports from different branches and moved the story from one terminated contract toward a wider collective campaign. In 2012, after MPs raised concerns, Post Office Ltd appointed the forensic accountancy firm Second Sight to review cases involving alleged Horizon problems. The CCRC says Second Sight concluded that Horizon could, in some circumstances, be systemically flawed from a user's perspective and that appropriate support had not necessarily been provided. It also records that the firm was denied access to some of the information it requested. That finding challenged the assumption that a Horizon figure was the final word on a disputed branch account. The review put two questions together: whether the technology could produce apparent discrepancies, and whether the people using it had been properly supported when they reported them. The dispute had moved from an individual balance to a review of the system and the support provided to its users. In March 2015, Post Office Ltd stopped Second Sight's work and closed its mediation scheme. The CCRC records the date, while Computer Weekly reported that the decision came on the eve of Second Sight's full investigation report. The scheme had given affected operators a formal way to submit disputed cases for review and mediated resolution. The closure was a post office action that ended the mediation route without resolving the merits of the disputed balances. Operators who had been using that route could no longer pursue complaints through it. The practical question became where the unresolved cases could go next. The answer was collective litigation, a high court action in which claimants could raise common questions about branch accounts, contracts, and Horizon's operation. That change shifted the dispute from a post office-run mediation process to a court-managed challenge involving the affected operators. After the mediation scheme closed, the affected Subpostmasters changed strategy. Computer Weekly reports that around 1,000 former Subpostmasters applied to join a court action, but the case proceeded with 555 against Post Office Ltd. This was no longer a series of separate complaints asking for individual explanations. It became a coordinated civil claim, with the group able to put shared questions before one court. In January 2017, the High Court approved a Group Litigation Order to manage the claims. The order gathered the common legal and technical issues, what the Subpostmasters contracts required, what cash and stock Horizon said should be present, and how its figures were being used when branch accounts showed shortfalls. The dispute was now managed as a shared case rather than as isolated branch complaints, allowing the claimants to test the system and the contract together. The order did not decide liability or award individual losses. It organized the litigation so common issues could be tested in one court case. The first of 4 planned trials began in November 2018, moving the dispute from mediation into evidence before the High Court. 2 High Court judgments, delivered in March and December 2019, reshaped the civil action brought by the 555 Subpostmasters. The judgments tested both sides of the dispute. One examined the contractual relationship between Post Office Ltd. And the Subpostmasters. The other examined how Horizon operated. 4 trials had been planned, but the parties settled after those 2. The court found for the claimants on almost all points and criticized Horizon's integrity, robustness, and operation. That finding cut directly against the Post Office's long-standing position that Horizon's figures could be treated as proof of an actual loss. In December, Post Office Ltd. conceded and settled. Computer Weekly reports that the settlement was £58 million before legal costs, with approximately £11 million left to share after costs. The civil case also produced material later used to challenge Horizon-based criminal convictions. But this was a negotiated agreement, not a judgment assigning every claimant an individual loss figure. The settlement ended the group's civil action, while questions about convictions, compensation, and accountability continued through later legal and official processes. The High Court group litigation had supplied material with which Subpostmasters could challenge convictions based on Horizon evidence. In December 2020, Southwark Crown Court quashed 6 Horizon-based convictions, the first such quashings in the Horizon cases. The Criminal Cases Review Commission then referred 42 linked cases to the Court of Appeal. Together, those steps moved the dispute from branch accounts to the legal safety of convictions connected to Horizon evidence. The 6 quashings changed the position of the people involved. The referrals opened a larger appellate stage, in which the court would examine the prosecution records in the individual cases before it. The next question was how the Court of Appeal would assess Horizon's role in each prosecution. The Court of Appeal did not apply one automatic answer to every Horizon prosecution. It asked whether Horizon data had been central to the individual case and whether the prosecution had independent evidence of an actual loss. Where the system's reliability was central and independent evidence was absent, the court held that a fair trial had not been possible. It also considered whether guilty pleas could stand where non-disclosure and abuse of process affected them. 3 of the 42 referred appeals were dismissed because Horizon data had not been essential to those prosecutions. The CCRC's current case pages list 77 Horizon convictions referred to appeal courts and 69 overturned. For the people whose convictions were overturned, those convictions can no longer stand. That changes their legal position and places them in a different redress category from people who were pursued financially but never convicted. But 69 is a count of convictions, not a head count of subpostmasters, and it uses a different population from the 555 who brought the High Court action. In the latest government table, covering data to 26 June 2026, 63 members of that original group had overturned convictions, while the other 492 were listed in the group litigation category for people without convictions. The distinction affected how officials recorded claims and which compensation route applied. Conviction cases were handled through the Horizon Convictions Redress Scheme, while the 492 sat within the GLO scheme. For the institutions involved, the figures describe separate tasks. The CCRC and appeal courts dealt with criminal cases, while government schemes processed civil claims. On 24 May 2024, the Post Office Horizon System Offences Act received royal assent. The Act provides for qualifying convictions to be quashed in England and Wales and Northern Ireland, and for certain cautions to be deleted. This was a statutory response to Horizon prosecutions, based on qualifying conditions set out in the legislation. The Act did not quash every past post office prosecution. Its defined scope determined which convictions and cautions could use the route. That scope was separate from the 555-member group litigation, a civil action rather than a statutory definition of criminal eligibility. The legislative route changed the process for qualifying cases. It reduced the need for most qualifying people to bring individual appeals, while cases outside the conditions remained outside that statutory remedy. Parliament had added a lasting remedy alongside the civil settlement, redress schemes, and appeal court work, without merging those different routes or their separate populations. Capture followed a separate path from Horizon. It was a pre-Horizon accounting system, and a Kroll review published in September 2024 found a reasonable likelihood that it could have created shortfalls. In October 2025, the government announced a capture redress scheme for people without a related criminal conviction. People who believed they had a capture-related conviction were directed to the Criminal Cases Review Commission instead. The split mattered. One route handled administrative redress, while the other began a criminal review. Keeping capture separate prevents its cases from being folded into the Horizon litigation and redress story. Should people with possible capture convictions receive the same public scrutiny as the Horizon cases? For more evidence-led investigations, subscribe.